Welcome everyone to Widener University Commonwealth Law School. My name is Professor Christian Johnson. I'm also the Law Review Faculty Advisor. Welcome to our annual Law Review Symposium, Pandemic Practices, COVID-19 and its Impact on the Law. I'd now like to turn the time over to the editor of the symposium this year, David Sweetman. I'll turn the time over to him.
Thank you, Professor Johnson. So, as he said, today is this year's edition of the Law Review Symposium presented by Widener Commonwealth Law Review. We have the pleasure of having Federal Magistrate Judge Joseph Saporito with us today as our keynote speaker. Judge Saporito took duty on February 12th, 2015 as a federal magistrate. Before that, he graduated from Scranton Prep High School, Villanova University, and Dickinson School of Law. Also, before taking the bench, he practiced as an assistant public defender in Luzerne County, and also in private practice in numerous solicitorships. So without further ado, I know you guys, everyone here is not here to hear me talk, but him talk. So I will turn it over to him now.
Thank you, David. I appreciate that introduction, and good morning, everyone. It's good to be with all of you today. I know that we're in a virtual setting, and that seems to be what we've been doing over the course of the last year is a lot of virtual work, but fortunately we've been getting it done. We've had our challenges. We've seemed to have overcome most of those challenges. Our reaction and what we do in response to COVID is primarily a work in progress. But I think that we, in our court, especially in the United States District Court for the Middle District of Pennsylvania, I believe that we have been successful primarily for two components. And the first of which is that we've had good leadership in our district. When COVID first began, our chief judge at that time was Christopher Connor, and he undertook the reins of getting us on track and doing what we had to do and becoming CDC compliant and trying to maintain our work, and at the same time being compliant and responsive to the needs and the challenges that COVID has given all of us. And the second component of of things working out in our district is the cooperation that we've had from the court staff, the court security staff, the lawyers and the litigants, and most importantly, the court cleaning staff. They've done a tremendous job in keeping our buildings pristine and sanitized at all times. So I would be remiss if I did not acknowledge the good work that those men and women have done over the course of this last year. They've been a tremendous asset to the court system. So when we were faced with the challenges that COVID brought back in March of last year, like everyone, we thought we were going to be doing this for probably 2 weeks. If you will recall, it was all about 2 weeks to stop the surge and so on and so forth. And so what we did was, and what our court imposed was a 45-day hiatus of no in-court proceedings. So that basically would have taken us somewhere to May 1st or thereabouts. And then as matters progressed, it took us to the middle of August for us to have some ability to overcome some of these challenges. And then it wasn't until mid-August that we resumed in-court proceedings. So what did that do from our standpoint? It provided us to learn what it is to work from home in many instances. From my perspective, I sit in the United States Courthouse here in Wilkes-Barre, and this courthouse also houses the United States Bankruptcy Court as well. And so at the time, it was just myself and Judge Opal, who was a bankruptcy judge in this building. And at that point in time, Judge Thomas, who was also a bankruptcy judge, he had passed away the year before. And a senior district judge, Judge A. Richard Caputo, was on vacation in Florida when this outbreak occurred. And he died 3 or 4 days before the outbreak of COVID. So it was just myself and Judge Opal here. So I missed the first week. I stayed home the first week, and then I came back after that first week. It was difficult working from home. So being the only act in town for the most part, it was easy for me to come back into this building and do what I had to do. But my staff was out and working from home until June the 1st. So it was basically me and the court security staff here in this building. Now, our courthouse has our court has 4 courthouses. Here in Wilkes-Barre, there's one in Scranton, there's one in Williamsport, and of course, there's one in Harrisburg. And those other courthouses were all impacted, sometimes in the same way, and in other times in a different way, because of the outbreaks and the surges that would happen in different parts of the state. So we've all tried to balance the outbreaks with maintaining our work and doing what we're required to do constitutionally, and also to provide the service that we're required to provide to the litigants who litigate their cases in the United States District Court. So we've also been fortunate because even long before COVID, our court system implemented the electronic case filing system. And so as a result of that, all of our filings are uploaded in our case filing system. So lawyers and litigants were not hampered by COVID from filing their documents. They don't have to literally come to the courthouses to file documents. They can file them electronically, and then we get to see them as they're filed, basically. So our written work has not stopped at all. We've not had one delay in our written work. And as many of you may know, in federal court, we write on just about everything. And I know I'm going to be facetious when I say this, but we even write on the best way to get to the restrooms from time to time, as opposed to we have an opinion on that. We have an opinion on a lot of things, but we write on just about everything that we work on in federal court. There's an opinion somewhere out there, and I think that's it's a service to the lawyers and to the litigants, and as well as the public. And people know the reasoning for our decisions, and that's primarily why we write on just about everything that we do. So we were still able to have our clerk's office and the employees, most of them were working from home, and as well as some would come in from a skeleton crew and work from their respective offices throughout the district. But for the most part, we learned the concept of working from home. We have also learned to be versatile in trying to work in different locations. So from that standpoint, did we learn something? Yes, and we've learned that we probably going forward are going to continue to implement some of the protocols that we've established in terms of the platforms that we work from now. But in every one of our courthouses, you can't walk in without seeing hand sanitizers, signs about masks being required to be worn. And if you don't have a mask, we'll provide one for you. There's gloves in sanitary gloves as well. And some of our courtrooms have had the benefit of having plexiglass installed in the jury boxes and in the witness boxes. In addition to that, we've also, as I've indicated earlier, we've had an increased cleaning and sanitizing. As I've said, the cleaning crew through the General Services Administration has done a fantastic job in keeping our buildings pristine. They've always been pristine, but they're not only pristine, they're sanitized pristine, if you will. And we've learned the concept of social distancing, and I'm sure we've heard that term now ad infinitum since last March. And so we've learned to do a lot of things that we were not accustomed to doing. Before, you would think that anybody that walked into, especially a federal courthouse with a mask on, I think they would be taken into custody immediately. Now it's standard protocol that you walk in here, if you see somebody without a mask, they may be taken into custody. I'm kidding when I say that, but you get the point, is that the whole thing, we've done almost like a 180 with how we do certain things. And so what platforms have we used? We've used, obviously, Zoom. Zoom has been an enormous help to our court system. We've also used WebEx, and WebEx has also been an aid to our system as well. Early on, I guess Zoom didn't provide some of the protections that we were looking for, and that's why we used WebEx from the beginning. And I don't know if any of you are stock market aficionados, but if you looked at the Zoom stock in March of last year, it was trading at about $100 a share. And throughout the year, it went as high as $588 a share. And it's now trading somewhere in the neighborhood of the mid 300s. So even their stock has seen the benefit of what they provide. We've also engaged in a lot of teleconferencing. We did a lot of teleconferencing even prior to Zoom. A lot of our case management conferences, scheduling conferences, discovery conferences were done telephonically. And we are continuing to do that telephonically as well. And of course, we do have some challenges in criminal cases using the virtual platforms, because in all of those cases, in order for us to have a case virtually, the defendant must consent to the proceedings being conducted virtually, because they have the right to appear in person in court. And so, but I have to say that was with few exceptions, everyone was very cooperative in having their matters heard virtually. And that has continued. We resumed our jury trials last year in late August, and we went through mid-November. And then from mid-November through March 1st, we were suspended again with jury trials. And then our criminal jury trials resumed March the 1st. And then our civil trials will now resume July the 1st throughout the district. And so what kind of proceedings do we have? We've also had, in some certain instances, some defendants have consented to entering guilty pleas virtually. They've consented to sentencings virtually. We've had initial appearances and detention hearings virtually, as well as evidentiary hearings. And we've had oral arguments in civil cases virtually as well. We've even, there's been some discussion about having jury trials virtually, but we've all recognized the challenges that may bring. And I don't anticipate that happening anytime soon. But from our perspective, nothing is off the table, I can assure you of that. And our innovativeness and the innovativeness of the technological advances that we've been able to take advantage of over the course of the last year have been very instrumental in allowing our court to continue the process of doing what we do on a daily basis. But these platforms don't come without some downsides. And for example, many times, some of the lawyers and many of the litigants feel that, oh, well, since I'm appearing on camera and I'm at my home, I don't have to be in court, for example. I'm not in court. I don't have to worry about wearing a suit and tie or being appropriately dressed from a woman's perspective, or being appropriately dressed from a litigant's perspective. And you'd be surprised as to how many times some people are don't take the virtual appearance as a court appearance. And we try to impress upon everyone that these are court appearances, despite the fact that we're not physically in the building. We may be physically in the building, but the participants may not necessarily be in the building. So we do take that seriously. And there's no formal dress code, but especially if you're appearing in court, and it's virtual, assume that you're actually in the courtroom. So, and to be dressed appropriately, and your demeanor as well should be appropriate as well. We have relaxed and are flexible about sometimes a telephone call will go off. Maybe the children of some of the lawyers or litigants may enter the room, and it does bring some levity to the moment. Sometimes you might see a cat cross somebody's desk, or you might see a dog bark or hear a dog bark. So yes, it does bring a lot of levity to the moments, and we've had our share of that. And I don't know if many of you, if you're ABA readers, the ABA Journal recently had an article in there that someone was delivering an oral argument in the United States Supreme Court, and somebody thought that they heard a toilet flush in the background. So I think there's been a whole lot of things that have developed over the course of the last year that no one ever anticipated and no one ever expected. So in terms of how we deal with these things from a in-court perspective, and what we've done, we've implemented the 6-foot rule. As you know, that we have to have 6 feet from everybody that's in the courtroom. And so it's required us to get out measuring tape, literally, and mark off the 6 feet from where people sit, from where people stand, how they enter the courtroom, things of that nature, and where the public may sit from the gallery's perspective. And so when we resumed our trials last year in August, from August to mid-November, I presided over 4 jury trials here in Wilkes-Barre. And what we did was my staff went out and they
put it in a
they
container.
literally marked off 6 feet from the jury box, from everybody. And we were able to, in civil cases, we seat 8 jurors at one time. So we start out with a panel of 34, 35 jurors, and we use 2 different courtrooms to have those jury selections. So from that standpoint, we were able to seat 5 men and women in the jury box and 3 outside of the box once they were selected. Witnesses were also required to, when they were called to testify, they would come to the witness box and testify. They would remove their masks when they testified, so that there was a need to see facial expressions regarding testimony and things of that nature. We use different types of masks as well. We even implemented a clear mask as well that we've used, and sometimes they look a little funny, but at least you can get to see the facial expressions of the people that are testifying and things of that nature. We've also had to deal with witnesses appearing virtually. In these cases, I had a witness appear from Texas, a witness appear from California, and one from North Carolina. And the California and Texas witnesses, we had to be mindful of the time zone differentials, especially the California witness with the 3-hour time zone. We obviously arranged for that witness to be called as a witness in the early afternoon, so that it was mid-morning thereabouts in California. And the Texas witness, although they're only an hour behind, we still had to be mindful of that time frame. And obviously with the North Carolina witness, the Eastern time zone, it was not a problem. But I want to point out one of the things that came up during the course of these witness examinations virtually is that, as you know, and you can't watch a news channel anymore without seeing somebody virtual as well. And when somebody's being interviewed, you get to see, they usually sit, with a bookcase of books behind them and all different things. Here, I guess you could see my flag, you could see some diplomas hanging from the wall and things of that nature. But I would tell you that if you're ever going to have a witness appear virtually, to be very mindful of the background of the witness, because we all have the tendency to see, oh, I see a book back there. What is that person reading? What book? I'm anxious to see or interested to see what's on there. What's that little trinket on their bookcase? And you're missing the point of the testimony. And I would also add that if you have a witness that is very impactful, and you're going to make a lot of impact with a jury on a certain witness, you may want to reconsider having that witness appear virtually, because it does take the wind out of the sails of the witness. There's no doubt about it. And then you have to have your fingers crossed and sometimes hold your breath to make sure that you don't have a glitch in the virtual setting as well. So those are the things that we've all tried to work out. And then after each of those 4 trials that I had, and I know some of my colleagues do the same thing as well, we asked the jurors afterwards, while they're seated in the box or seated outside the box, depending upon how many we have there, of course. We've asked them, number one, did you feel safe while you were in our building here? And without a doubt, 100% have always said yes. Did you mind the protocols that we had to implement? Everyone was cooperative and said, no, we kind of just went with the flow and did what we were supposed to do. And then the other one, was there anything that we could have done differently to have made your stay here a little bit better? And there was only one question that was asked with that. And the question was, why don't we have cafeterias in our building? And that's a very good question. We probably should have cafeterias. And sometime in some of the buildings, we've had them in the past. Here in Wilkes-Barre, we do not. We have vending machines, but we also have restaurants across the street from the courthouse and down the block from the courthouse as well. And so we were able to give some flexibility to the people for lunchtime and things of that nature. But what they did was, when they would convene in the morning, they would assemble in a separate courtroom so that they'd have substantially more than 6 feet away from each other. And they would deliberate in a courtroom, not in a jury room. So we had to make some changes there. And after every witness that testified, we'd have the witness box, the chair, the desk that may be in front of the witness, the microphone, everything was re-sanitized. So we had the cleaning crew come in, and they did another yeoman's effort of making sure that the next person that was going to sit in that box was pristine as well and completely sanitized. So that created some delay as well. And now, as I mentioned earlier, our criminal trials resumed in March, and our civil trials will now resume again in July. And so far, we're still implementing many of those same protocols that we've done in the past. And as many of you may know, the federal system prides itself basically on the uniformity throughout the country in terms of what we do, and whether it's the products that we use, as well as the services that we like to deliver. We pride ourselves on the uniformity of our system. But the chief judges of the 94 districts of the federal system are tasked now with determining how each district should approach hearings and trials and sentencings. So, and usually the result in each district is a product of local infection rates and things of that nature. As I've indicated, here in the Middle District of Pennsylvania, where we have 4 separate courthouses, we've had surges in each of our communities at different times. Here in Wilkes-Barre, which is the county is Luzerne County. Luzerne County has seen surges multiple times throughout the course of this past year. Fortunately, everyone in our building here, we've been fortunate enough not to have been faced with the virus. And now that most of us have been vaccinated, we feel much safer now as well. And even the state systems nationwide, many states have guidelines. As many of you may know, the Commonwealth of Pennsylvania has had its own guidelines, and in many instances, the Office of Administrative Courts of Pennsylvania had to implement certain rules as well. And so, but many states and their courts differ by county and sometimes by courthouse location as well. So these challenges that we've faced here in federal court have been faced literally throughout the nation in every courtroom that is state or federal that has been faced with these challenges. And we've tried our best to overcome and meet the challenges as they've arisen. And we've done as best as we can to make sure that the litigants are still having their cases litigated as promptly as possible. And it has prompted, as a result of this COVID, it has prompted an increase in settlement conferences as well. And so we've engaged in settlement conferences virtually. We've been fortunate enough to have had a substantial success in resolving cases virtually. We, as here at the Magistrate Judge Corps of our district, we do a lot of settlement conferences as well. In fact, I had 2 this week, and both of which settled. The Zoom platform allows you to break out into different rooms. It's very compatible from that perspective, and it allows for you to have some confidential communication with each side separately, and then you can bring everybody into the same room. It does require some becoming somewhat adroit in navigating the Zoom platform, but once you get used to it, it's not as bad as it sounds, or you may think it is. Do I think that virtual platforms are here to stay? Yes, I do. I think that they are to a certain extent. I don't think that we'll see many jury trials on a Zoom platform. You may see some bench trials, though, on a Zoom platform. But the jury trials, there's nothing like being physically present and letting the courtroom breathe, so to speak, and feeling the trappings of the courtroom and having the trappings of the courtroom to help the litigants also resolve their case as well. There's always that feeling when you walk into a courtroom. It's always, I know I'm prejudiced when I say this, but we look at it as it's a place of reverence, and it's a place of respect, and so on. And so it provides you with that ability to feel the courtroom and to feel the sense that it's a hallowed hall where justice is administered, and that's what it's supposed to feel like. And so sometimes we're missing that with these virtual appearances. So I know that I've probably gone over my 25 minutes here, but I'm happy to take any questions that anybody may have, and however you want to shout them out, I'm happy to address them for you.
At this point, if you do have a question, please raise your hand and we will unmute you to ask your question. We do have a question from the chat.
Okay.
The question is, do you think that virtual trial will lead to confrontation clause challenges?
That's a very good question. I do in so many different ways. And that was what I was alluding to earlier when I was talking a little bit about making sure if you're going to have an impactful witness, you want that witness to be able to be in the setting in the courtroom, to have the impact that you want. And in many cases, where in criminal cases, especially when the case can be won or lost on a vigorous cross-examination, you just don't get to see the full flavor of the witness testimony. You don't get to see how the witness sits and responds to certain questions, whether the witness is squirming in the chair, whether the witness is fiddling with the papers. There's so much that we can hide behind here virtually. You only get to see a certain setting, and you're limited in that. It would not surprise me if we get confrontation challenges over the course of time. I don't know how it would pan out, but in terms of getting the challenges, I certainly would anticipate that to be the case at some point. And it would require, obviously, the preservation of the record at the appropriate time to make sure that it's preserved for appeal. And that, so defense lawyers, I'm sure, would be looking to make sure that that I is dotted, that T is crossed, and it will require lawyers to be on his and her and their feet to make these challenges as well. So I do think that we'll face it at some point.
Hi, I had a question.
Sure.
My name's Tracy Updike. I practice bankruptcy law, so of course know Judge Opel, and I think he's been retired for about a week now.
Yes, he has.
I don't know if you had any communication with him about his caseload, but of course our bankruptcy caseload is down significantly during the pandemic. I'm just wondering to what extent you see your federal civil filings. Have they decreased? Have they increased? What's the situation as far as the number of suits that you see moving forward at this time?
Well, you're correct about the bankruptcy filings. They are down. And before Judge Opel left, he and I communicated, and he did talk about the caseloads have decreased over the course of time. And to me, I actually thought it would have just been the opposite over this last year, but it has not turned out that way. But in terms of our civil caseload, our civil caseload has not changed at all. We are, despite being a court of limited jurisdiction, we are very busy. We get new case filings on a daily basis, both cases that are counseled and cases that are filed by pro se litigants as well. So our civil caseload has not been diminished by the pandemic. I can assure you of that. We still see our fair share of them. We get a tremendous amount of prison litigation here in federal court, and that hasn't diminished either. We did early on, we had a flurry of activity from prisoners seeking release based upon COVID and their personal circumstances. Substantial majority of those requests were denied. In rare exceptions, some were granted as well. But our civil case filings have not been adversely affected. They've probably remained the same, or maybe there's been a slight increase. I hope that answers your question, Tracy.
And now I think we will turn it over to Professor Domino to ask. Oh, I'm sorry. We have another question.
Okay.
Raise their hand, so we'll take that one first.
Good afternoon. Hello. I would like to ask, in the recent years, the judicial system has been at the center of a struggle between preserving its renowned traditional system and mounting pressure for it to modernize, to keep up with the huge technological advances of the society that it serves. Do you think that we could leverage the pandemic so it can be a catalyst that is needed for change?
The answer to that question is yes, and here's the explanation for it. First of all, and fortunately, we don't lack for too much in terms of technology in the federal court system. We have state-of-the-art equipment here, and especially when the lawyers are presenting their cases. They usually come here a week or two before their cases start to upload their evidentiary materials that they want to put on our computer screens and on the screens that are situated throughout the courtrooms. And so pretty much the technology-wise, we usually have, there's always an IT person initially from the court that usually stays with the case, usually the first day or two, just to make sure that it's clear sailing from our systems perspective. But usually the lawyers bring in an information technology person with them to make these presentations. And our courtrooms are well equipped for the technology that exists nowadays. So, but can it be used to implement certain things? Yes, I do. I think you may see us taking advantage of, and I don't mean this in a bad way, taking advantage of the circumstances, learning from the pandemic. In many instances, where some people were forced to work from home, the court system was able to provide technology to be able to be so that you can work from your home. And so, you know, they made the process easier for us to deal with the circumstance. And we've often said here that how grateful we are that we have the ability to be versatile in this virtual world, and that we can work in different locations and still get the job done and get it done the right way. And so that's so yes to your question, and I think that that's the explanation. We've been fortunate enough to have the technology advancements that we've had, and we have the ability to implement and utilize all of this technology in our courtrooms, and now in most cases from almost any setting that we're in.
All right, so now we'll turn it over to Professor Domino. Professor Domino to ask some questions and further the discussion. Professor Domino is a professor here at Widener Commonwealth. For me, he was my con law professor, but I do believe now he teaches some criminal law as well. But I did not have the pleasure of having him for that.
Thank you, David. Yes, criminal law, criminal procedure, constitutional law, election law, whatever else needs to be taught. Judge, thank you very much for appearing. It's an honor for the law school, and I'm sure it's a great pleasure for the students and other members of the community who were able to join us. So thank you very much for your appearance.
You're welcome, and the pleasure is mine. It's just as much of an honor for me to be with you as well. So I'm grateful for the opportunity to be with you today.
I wanted to pick up on a couple of the points that you mentioned, and then also ask you about some things in a slightly different direction.
Sure.
But first on one of the items that you had talked about already, the idea of witnesses appearing virtually. And I was intrigued by your suggestion that counsel should be strategic in deciding whether to call a witness virtually, because the witness is likely, at least this is how I took your remarks, the witness is likely to be less effective on direct examination, but the cross-examination may also be less effective.
Yes.
Is it then, is it up to counsel on both sides whether that witness will appear live or virtually? Do you have to get consent from, or is the procedure to get consent from both sides before a witness is allowed not to be in the courtroom?
Well, in these three instances that I had, we had consent from everybody, and the reason why was because if you take the witness from California, during that time frame, if you will recall, If you traveled from another state and you came to the Commonwealth of Pennsylvania, you were required to quarantine for 2 weeks when you arrived in Pennsylvania. So they wanted to avoid the expense of having to have the witness come here 2 weeks in advance, put the witness up in a hotel room somewhere, and then say, okay, now you can come into the courtroom. So it worked from that perspective, but that's a very good point, Professor, where if you don't have consent, I don't believe that you're going to be able to present your case virtually. You have to be able to have that witness in the courtroom, and it's even a greater impact. As we all know, sometimes cross-examination can make or break a case, and it's the logistical aspects. You want to show a witness a document for identification purposes. Sometimes virtually it comes up on the screen, and in some instances, depending upon who's doing who's at the controls, sometimes you only get to see the document on the screen. And sometimes you get a split screen where you could see the document and you could see the witness. But in some of those instances where only the document was appearing, you wouldn't see the facial expressions of the witness, and yet the lawyers were still asking the witness some questions, and then you were only getting the audio. And so that's the point I was trying to make, where you don't have the impact, and it just kind of like it's a big letdown. That witness was supposed to be the witness, or a witness who was supposed to have such a big impact upon this case, and we've just literally taken the air out of the balloon and it just fizzled out. But to answer your specific question about consent, I think that if you don't have consent, I don't think that the witness can appear virtually on direct exam and in person on cross-exam. We haven't had that issue come up, and quite frankly, I hope I don't have that issue come up. But if I did, I think I would have to hedge on the side of having the witness appear in person.
And do you have a concern for appeals if there is no in-court option for a trial or a hearing, any kind of proceeding? Are you? I think we're trying to see a light at the end of the tunnel for this pandemic. So perhaps now for March for criminal cases and July for civil cases, we're going to be able to get back in the courtroom. But certainly there is a concern, or has been a concern over the last year, that if people are put in the position of either not having a trial or having a virtual trial, do you have a concern that neither of those options is good enough, that either the Constitution guarantees an in-person trial or that there's some other requirement that we have a trial in the traditional sense?
Yes, we've all faced with the old adage that justice delayed is justice denied. And so from that perspective, the unfortunate aspect is that many cases have been delayed because of the pandemic. But despite the fact that the delay exists, I do think that as time passes, we're going to be faced with the constitutional guarantees of a trial by a jury of our peers. And does that mean that we can have it virtually, or does that mean we can have it in person? I think it means that I think it's more of an in-person requirement. The virtual platforms are great for certain aspects of doing what we do, but it certainly doesn't pass muster, I don't believe, in terms of giving litigants their literal day in court. They expect to be here. They expect to litigate their case the way that we've been accustomed to litigating cases. And I just think that I know someone asked earlier about the confrontation clause. I think that that's also a viable potential issue that will be raised as time goes on here. And it depends on whether or not judges are willing to experiment with virtual trials. Some judges throughout the nation have had criminal jury trials, or no, I'm sorry, civil jury trials. Somebody have tried it, and they found that there's been too much distraction, and you can't really keep your eye on the jury, the witness, your notes in front of you, without having the periphery of the courtroom all intact when you're inside the courtroom. So I do think that we're going to be faced with a lot of those dilemmas, and I do think it will require consent.
Thank you. There's also another constitutional concern that hasn't been as much on people's minds, I don't think. People have understood the concerns about delaying court proceedings and confrontation, and that all makes a good deal of sense. But what about the public trial right? That if we create trials that are virtual, or even if we apply this 6 feet rule and expand the jury box into the spectator area, and we allow very few or no people just from the public into the courtroom, has it been much of a concern that trials stay public, in a sense that members of the general public can just walk in and make sure that justice is being done adequately?
That's a good point. I think what you're going to see over the course of the next few years, I think you're going to see some rules being relaxed about cameras in courtrooms and things of that nature. I think you're going to see more televised trials. I know we see it in certain jurisdictions now, and they've been doing that for some time, but I think you're going to see it become more prevalent over the course of time. What we've done here, and I know that other courts throughout the nation have done as well, is they've created a separate courtroom where the trial is streamed into that courtroom, so the public can sit into that in that separate courtroom and observe through the computer screens and the television screens that are on the walls and so on. They can observe the trial that way publicly. Some people have also called chambers and asked chamber staff to provide them with the Zoom link for the proceeding that's going to take place on that given day, or the WebEx link that's going to take place on that given day. And since matters are open to the public, we feel that if it's a public proceeding, they have the right to appear, and if we're having it in a virtual platform, they have the right to appear virtually and observe that way. So those requests are basically met with giving the benefit of the doubt to the public, so that they have the right to see and hear what's going on inside the courtroom. If it was a closed proceeding, that's a different story. But if it's an open proceeding normally, and if somebody picked up the phone and called chambers and said, could I have the Zoom link for the matter of Smith versus Jones that's going to happen later today, I think we're obligated to provide it to them. And I think that's why you're going to see in the future, I think you're going to see the rule about courtrooms or cameras in the courtrooms being relaxed, I think, to a certain extent.
Has there been experiment with regard to procedures like that on a judge by judge basis, or is that one of the areas that has been coordinated across courtrooms within a district or within the federal system?
That I don't know. I know in talking with some of my colleagues here, I know that there's been a few of my colleagues that have had requests from members of the public for Zoom links, and asked to be able to observe by way of a Zoom link. So I know that exists, and I know that it's happening, and it all depends on the nature of the case. Most civil cases don't generate the public interest as a criminal case may generate. But for the most part, depending upon the nature of the case, you don't see that many crowded courtrooms, and the galleries are not as crowded as one may think that they are. Sometimes.
Could you talk a little bit more about the need for coordination across courtrooms during the pandemic, you started off by mentioning the leadership of then Chief Judge Connor and
now
Jones now
Chief,
has become Chief
now
Judge.
Chief Judge Jones, yes.
Yeah, what kinds of coordination has there had to have been made? Things like not scheduling proceedings in different courtrooms at the same time because of taxing the security staff or that kind of thing.
Well, that's one of them. In fact, that's still existing today, where they want us to, if take Harrisburg and Scranton for the most part, if there's one trial going on in one of those vicinages, they want only that trial to be going on at that time. So many cases say, well, if my case is getting priority today, oh, well, that means that my case has to take a back seat to them because that case came first in time. So yes, we're trying to eliminate the numbers of people that come into the courtroom and in the courthouses in a given case, where normally you may have had 2 and 3 trials or maybe 4 going on at one time. Right now, it's only 1 per building, basically, is what it amounts to. And so that's happened a lot in Harrisburg and Scranton. In Williamsport and Wilkes-Barre, not as much. But initially, from our perspective, what we do here in Wilkes-Barre, we're considered part of the Scranton vicinage as well. So if in civil cases, for example, if I'm going to pick a jury in a civil case here, and there's a case going on in Scranton, we have to coordinate with the Scranton vicinage as to whether or not we can now select our jury, because we need a jury clerk here during the jury selection. So that has been up in the air. Ordinarily, that's not a problem. As you said, that's one of the things that both former Chief Judge Connor and now Chief Judge Jones has implemented, and they've also implemented what we call a 4-phase process. And in our phases are such that, you know, we're back to phase 1, which is limited in-court proceedings. And when at one point we were up to as close to phase 3, and phase 4 is getting back to normal without any restrictions. But then when the surge came in the fall and into the early winter, we went back to phase 1 again, where we weren't having any in-court proceedings. So yes, we've operated under this process of 4 separate phases, and that's been done through our chief judge, and he's been very instrumental in implementing that. And what Chief Judge Jones has done so far during his tenure since June of last year, he's assembled a COVID task force in the court system, and we meet just about every 3 weeks. We meet in a virtual setting, and we just had our meeting actually this past Tuesday, and I'm on that committee because I sit here in Wilkes-Barre, so I have input from the Wilkes-Barre vicinage, and that kind of thing. And then our Magistrate Judge Susan Schwab, who sits in Harrisburg, she's been our COVID coordinator, and she's done an outstanding job in dealing with the protocols and implementing the protocols and making sure that if a court employee was contracted the virus, what has to be done, and to maintain the privacy of the individual as well. So she's had to walk on a lot of eggshells over the course of the last year, and she's done a terrific job doing that as well. So and Judge Jones he works by collaboration, and he brings everybody into the room, and he's asked for input, and he's asked for guidance from everyone as well. So I admire the leadership that our court has had over the course of this past year, and they've handled this as best as it possibly could be handled, in my opinion. And having seen other courts kind of like fall by the wayside and only taking certain emergency matters, we've still been managing to to deal with more than just emergencies. We've been able to implement these phases that we've been through, and basically during like phase one, there's all bench trials, jury trials, petty offense docket, in-person settlement conferences are not permitted. You can't have any ceremonial matters, naturalization ceremonies. You can't have those. In Scranton, where I'll preside from time to time or participate in naturalization ceremonies. We had a naturalization ceremony in the summer, and 2 weeks ago that was handled outside of the Scranton Federal Building. It was literally on the sidewalk where the candidates for naturalization and for citizenship would come in their car, drive up. We would swear them in, administer the oath of citizenship to them while they were seated in their car, give them their paperwork, and off they would go. So we've tried to continue that process as well. So I hope that answers your question, Professor, but I know it's a roundabout way of saying that, yes, our leadership has been instrumental in guiding us through these difficult waters.
Certainly, yes, thank you. And I know that we're running out of time, so I have just one final question. Sure. About looking forward. And the symposium is dealing with the effects of COVID-19, but that's not only on court procedures, it's not only looking back to the past year. Do you see the court business, the kinds of cases, do you see the court having to deal with cases that arise out of the pandemic? For example, do you see personal injury cases coming out of charges that people were infected by the virus? Is that something to look forward to over the next couple of years? Cases arising out of the federal legislation that has been passed in response to the pandemic. Is that something that the court system is concerned or has
I certainly anticipate that we will have our share of litigation out of the pandemic, and we've already seen from a civil standpoint a flurry of cases where business entities have brought claims against their insurance carriers for business loss based upon the pandemic. And for the most part, most of those have been resolved in favor of the insurance carriers, depending upon how the policies are written. But we've seen it from a business law standpoint already. That's already been, issues have already arisen in that arena. And I do anticipate that with recent legislation that has gone on, I feel that we'll be faced with it again. As you may recall, there was litigation that concerned making some businesses essential and others non-essential, and what that did and how that impacted on certain people. And the fact that there was really, since we were never faced with this before, I guess Governor Wolf decided to, in Pennsylvania, he said, well, I'm going to deem this business essential, this business non-essential. And then there was issues as to, well, where does this business turn to litigate the issue of, I am essential even though you're declaring me non-essential. And so I think that type of litigation may still see some play, but as the pandemic minimizes, I think you'll see issues of that nature go by the wayside.
Well, again, thank you very much. It's been a pleasure speaking with you, and it's been an honor to have you appear at the Widener Commonwealth Law School.
Well, thank you very much for having me. It was my pleasure. And if there's anything that I can do, I'm happy to do. I do have a lot of Widener students serve as interns and externs, and we're happy to continue to have them. We welcome them, and we hope that when they're with me, I hope that they're learning as much as they can. I know David was an extern here with me, and I have 2 Widener students right now in this semester as externs, and I'm going to have one over the summer as well. So we're happy to have you. I'm grateful for the opportunity to be with you all. I wish you all a good day and a wonderful weekend.
Thank you so much, Judge. And I
You're
did
welcome.
have the pleasure of externing with you, and that was a great opportunity. That was right at the beginning
Yes.
really of the pandemic, and when the court really started to shift to virtual. So it was pretty cool to see that, how that played out in the beginning.
Yeah, I know. It was you were on the beginning phase of that, and then you had to participate virtually, and we were all we had a lot of balls in the air at the time, and trying to not let any one of them hit the ground at the same time. But I think we were able to at least find our way, fortunately.
Definitely. Thank you again.
You're welcome. Nice being with all of you. Have a good day.